Queen, the Veil lawyer with Belter Law Firm. Was Katt Williams actually sued by Disney for trademark infringement of Cat in the Hat? So if you are like everybody else who watched the extremely viral interview, Club Shay Shay interview with Katt Williams and Shannon Sharp regarding Katt Williams' essentially tell-all, you may have caught within that over 2-hour interview that he said that he was sued by Disney for trademark infringement of Cat in the Hat. So me being the trademark attorney that I am and the trademark litigation attorney that I am as well, I said I need to look into this. So let me look into this and see, did Katt Williams really get sued for using Cat in the Hat? Did he get sued by Disney of all entities? Okay, so I looked into it, and do I believe that Katt Williams lied about being sued? Or he did say sue as well, but he also said that he was sent a cease and desist letter by Disney. And I need to clarify this for y'all, okay? This is a great misnomer in not only intellectual property litigation as well, but business litigation too. A cease and desist is not a lawsuit, okay? I'm going to repeat this. A cease and desist letter is not a lawsuit. A cease and desist letter is essentially the other party putting you on notice that they intend to file a lawsuit against you if you do not cease or stop doing whatever it is that they're asking you to do within that particular cease and desist letter. Nobody can make you stop doing anything unless it is a judgment from a court of law, a jurisdiction, and it is signed by a judge. That is what I want to put out there, okay? So just because you have received a cease and desist, it does not mean that you have to stop. Nobody can make you stop doing anything unless it is a judge. So, wanted to get that out the way. So, Katt Williams disclosed that at one point in time, he was not known as Katt Williams. That was not his stage name, his comedian stage name. When he first came on the scene, actually doing comedy, his stage name was Cat in the Hat. And he was only grossing like $25,000 a year while he was using the stage name Cat in the Hat. So while he was performing under the name of Cat in the Hat, he received a cease and desist letter saying that he was infringing upon the trademark of Cat in the Hat. But he also said that he was sent that by Disney. So that's what got my wheels turning, because I know that was before my time, but everybody pretty much have read Cat in the Hat, and we know that that is Dr. Seuss's brand. Okay, so Cat in the Hat is a Dr. Seuss brand and not a Disney brand. So me being the trademark attorney and the trademark litigator I'm logging into Pacer. I'm logging into the United States Patent and Trademark Office. I'm saying, let me look at this. Let me see who really owns the trademark to Cat in the Hat. So Cat in the Hat is an actual registered trademark, and it is registered and owned by Dr. Seuss Enterprises LP. Dr. Seuss has been around since, I think, the 40s, maybe even before that. But Cat in the Hat, that was actually published and released in the 1950s. So Cat in the Hat has been around for a while. Cat in the Hat has also never been owned by Disney whatsoever. There was a movie made, the Cat in the Hat film, that was made in around 2003, but it was produced by, I think, Universal Pictures and DreamWorks and some other companies as well. But none of those production companies and motion picture companies are owned or operated in any way, shape, form, or fashion by Disney. So I truly believe that Katt Williams is telling the truth, that he received a cease and desist letter for utilizing the stage name Cat in the Hat, but he just misspoke on the company that sent him the cease and desist letter. I think he got Dr. Seuss and Disney mixed up and confused. Now, if Disney actually, in fact, did send him a cease and desist letter for Cat in the Hat, what does that mean? That means that at that time, Disney was just being what we call in the trademark world a trademark bully. They was picking on somebody who they knew that they could send this information to, and the person would not challenge what they would say because they see the big name Disney. But from my research and everything that I have uncovered, Disney does not and has never owned any trademark rights to the Cat in the Hat brand. Not even the logos, not the cat, not the hat, like all of that, all those intricate pieces, even the word mark itself are owned by Dr. Seuss Enterprises LP. So I really truly believe that he was sent a cease and desist letter, but he wasn't technically sued because he was mixing up, oh, I was sued, but then I was sent the cease and desist letter, but there was not an actual true lawsuit, because if there was a true lawsuit, he would have been hit with a money judgment. So a lot of people think that when they receive a cease and desist letter that they're being sued. It's not that you're being sued. You're not being sued at that point. You're just being on notice that that other party intends to sue you. So he did not receive, well, like I said, the odds of him receiving it from Disney are very slim because Disney doesn't own Cat in the Hat. But if Disney really did truly send him a cease and desist, then they were just being a trademark bully, and that is out of line. But I'm not really a Disney person, so I never really watched Disney, never really wanted to go to Disney World, so I can feel comfortable with saying this on this live, but they were just being a bully. Disney was being a bully. If Disney really, truly, indeed did send him a cease and desist letter for utilizing Cat in the Hat, because trust me, y'all, I stayed up all night researching that, and all of the Dr. Seuss books, all of the names, all of the pictures, one fish, two fish, red fish, blue fish, like all of that is owned, it's registered in the United States Patent and Trademark Office, and it is owned by Dr. Seuss Enterprises LP. And if you go on Dr. Seuss's website, they have it plastered on one of their main pages that they are the #1 licensed children's books in the world. And also they are the #2 of the license for the celebrity intellectual property. So that means even, because clearly Dr. Seuss has passed away, so even after he's passed away, people still want to be associated with the Dr. Seuss brand, so they're doing that through trademark licensing agreements. And with trademark licensing agreements, if I am the licensor, which means that I'm the person who owns the brand, I'm the person who owns the mark, and you are the licensee, you're the person who is seeking to pretty much latch on to my brand and build your name and build your fame off of my name, then I'm never going to give you the right to have any legal rights or any claims to my brand. It's just not going to happen whatsoever. And if you ever see that in a trademark licensing agreement, whoever wrote it, because I can't imagine that a trademark, an intellectual property attorney would draft something like that, but you never know with these DIY websites. They'll just give you anything and you don't know, because they're telling you it's not legal advice. So you would never see that in a trademark licensing agreement that the licensor, that's the person who owns the registered mark, is actually giving away the rights and claims and legal claims to the licensee. So just wanted to clear that, because that's something that stuck out to me as a trademark attorney. I'm like, wow, he was sued by Disney. But then he said Cat in the Hat. And I'm like, well, hold up now. I know Cat in the Hat is Dr. Seuss. And Dr. Seuss is Disney? Like, when did Dr. Seuss become Disney? So the wheels just started turning. And no, Dr. Seuss is not Disney. And Disney is not Dr. Seuss. Dr. Seuss is his own brand. And there are beaucoup, okay? That's Louisiana Creole for a lot. Beaucoup registered trademarks under the Dr. Seuss Enterprises LP. So that is my educated opinion on Katt Williams' statement that he was sent a cease and desist letter and sued by Disney for using the stage name Cat in the Hat. But thankfully, Katt Williams, because that's not his real name. Katt Williams is his stage name. It's not his real name. He now has a trademark for Katt Williams. So now Katt Williams, he is in the position to send other people and other companies and other businesses and other brands a cease and desist letter and even sue them because his name is now trademarked. So he has a lot of power in his hands now. Well, he has even more power in his hands now since he owns the trademark rights to Katt Williams. Queen, the Veil Lawyer with Belter Law Firm.